Mr. Chairman, Excellencies, distinguished ladies and gentlemen, it is an honor for me to address you today on behalf of the Armenian National Human Rights Institution. I would like to thank the Armenian Forum for Security Cooperation Chairmanship for inviting me and giving me this opportunity to share with such a distinguished audience some of my observations as human rights defender on the issue of international humanitarian law during conflicts. From the beginning, I should say that I attach a particular significance to the participation of human rights defenders at such meetings, which should be considered as contribution of national human rights institutions to the overall protection and promotion of human rights. Our approach to human rights protection in the context of conflicts is based on the major premise of universality of human rights of all people and their protection, and no distinction shall be made on the basis of political, jurisdictional, or international status of the country or territory on which they live. This notion is reflected in the Universal Declaration of Human Rights. Human rights are key to the OSCE concept of comprehensive, indivisible, and cooperative security. Using this opportunity, I would like to highlight the excellent existing cooperation between our institution and OSCE executive structures, in particular ODIHR. The overarching concept of protecting human rights, including in times of conflict, is the foundation on which the international humanitarian law is built upon. The important role of national human rights institutions and ombudspersons in the protection and promotion of human rights in national contexts is widely acknowledged. At the same time, the state authorities have a positive obligation of incorporating human rights standards as well as international human rights norms and principles in the national legislative and regulatory frameworks. On the one hand, we have an extensive body of norms of IHL mandatory for implementation by states, while on the other hand, as usually the case with multilateral instruments, their application is limited by the readiness of states to respect and uphold the respective commitments and obligations. Subsequently, this creates certain handicap with regard to the implementation. In this context, the role of human rights defenders as well as relevant civil society organizations should not and could not be overlooked as watchdogs, as important oversight mechanisms or tools to ensure the implementation of state commitments and obligations. In times of conflicts, the work of human rights defenders aimed at monitoring the implementation of humanitarian law is indispensable for recording, reporting, and presenting the breaches of international humanitarian law and international human rights law. At a time when, along with existing conflicts, we see the emergence of new ones, accompanied by widespread human rights violations and resulting in humanitarian crisis, the significance of human rights protection in any territory is essential, and here is where the role of the national human rights institutions becomes ever more vital. I should perhaps also emphasize the important work that the OSCE conflict-related mechanisms and agreed formats could carry out. Mr. Chairman, it goes without saying that the international humanitarian law should be applied in all cases to protect civilians and persons hors de combat, meaning those not directly engaged in hostilities, and lessen unnecessary harm during armed conflicts. As the National Human Rights Institution, the Human Rights Defender of Armenia is entrusted with a broad mandate to promote and protect human rights in all circumstances and without exceptions, including in conflict and post-conflict situations. The Human Rights Defender is mandated also to report on IHL violations. Today, I would like to share with you the work that the Office of the Ombudsman of Armenia has been carrying out in cooperation with the Human Rights Ombudsman of Artsakh since the outbreak of war against Artsakh in September 2020. The consequences of the war have been further aggravated by the COVID-19 pandemic, resulting in rapid spread of the deadly virus, instigated by the collapse of the healthcare system, which in turn exacerbated the sufferings of the people. As a result of the war, around 130,000 people were displaced. The protection of the civilian population during the armed conflicts is the absolute requirement of the IHL. According to the general rules of protection of the civilian population, individual civilians shall not be the object of attack. Acts of threats of violence, the primary purpose of which is to spread terror among the civilian population, are prohibited. The indiscriminate attacks or the targeted attacks towards civilian communities infringe the right to life and health of civilians and are in absolute violation of the principles of international humanitarian law. The Geneva Conventions and other international treaties and conventions, such as Convention on Cluster Munitions, Convention on Certain Conventional Weapons, as well as the customary humanitarian law, limit the right to choose the methods and means of warfare, prohibiting the use of weapons which may cause superfluous injury or unnecessary suffering or damage military objectives and civilians or civilian objects without distinction. Thus, international legal instruments and customary international law prohibit the use of cluster munitions, considering them lethal and inhumane. As reported by the Artsakh Human Rights Ombudsman, the indiscriminate attacks on civilian communities and infrastructure with the use of high precision weapons and such banned munitions as cluster bombs and white phosphorus caused casualties among the peaceful population and major damages to the civilian infrastructure. This resulted in an unprecedented humanitarian disaster, violations of international human rights law and humanitarian law amounting to war crimes. The banned weapons, including cluster munitions and chemical incendiary weapons, were used against the civilian population of Artsakh during the war. In particular, LAR-160 and Smerch cluster warhead missiles were used against civilian communities of Artsakh, including the capital city of Stepanakert. Moreover, during the war, Azerbaijani armed forces used different types of combat unnamed aerial vehicles, such as Harop, Zaoba 1K, Sky Striker, Bayraktar TB2, AN2, clearly violating the principles of necessity and proportionality of IHL. Under international humanitarian law, journalists engaged in dangerous professional missions in areas of armed conflict shall be considered as civilians and thereby benefit from all the protection conferred by international humanitarian law on civilians. Their activities in conflict zones and war or military attacks have legitimate purposes and are under international protection. Several cases of deliberate attacks by Azerbaijani military on international and local media representative journalists, such as those including France Press, Le Monde, Doge, 24 News, etc., were registered already in the first days of the war. There is an absolute ban on torture and other cruel, inhuman, or degrading treatment under international humanitarian law and international human rights law. Substantial evidence, including numerous video footages disseminated via social media, attest to cases of arbitrary executions, brutal killings, and beheadings of captives at the hands of Azerbaijani troops. At the moment, the issue of prisoners of war and civilian captives remains one of the most pressing problems. The IHL norms stipulate that prisoners of war must be released and repatriated without delay after the cessation of active hostilities. This is Article 118 of the Geneva Convention number 3. It is a matter of grave concern that the Azerbaijani side not only continues to detain the captured POWs and civilians, but most importantly, refuses to reveal the exact number of prisoners of war it has in its custody. Azerbaijani side refuses to release this information to the ICRC as well. The human rights defender also cooperates with ICRC on issues concerning the return of prisoners of war and civilian captives in line with IHL requirements. However, our cooperation is not limited only to this issue, but rather aims to protect and assist all victims of the armed conflict We hope that the ICRC work aimed to address the humanitarian consequences of the war would not be obstructed further, and it would have a possibility to conduct its humanitarian mission properly. All the violations of international humanitarian law and human rights violations, such as right to life, health, property, etc., were recorded by the defender and his team through fact-finding and monitoring activities. The cases of grave breaches of human rights law, international humanitarian law, and customary IHL have been presented as human rights defenders' ad hoc reports and official letters to international human rights organizations confirmed by objective evidence. We share the result of our findings with our partners on a bilateral level, and I urge relevant authorities to look into them with the view of addressing the impact of international humanitarian law violations on the human rights situation in general. From September 27, 2020 to January 28, 2021, the civilian population of Artsakh suffered 72 losses, 41 killed as a result of targeted strikes, 31 in captivity, 103 civilians were injured. Up to now, a high number of Armenian POWs remain in captivity in Azerbaijan, and their return is artificially delayed. Moreover, there are criminal proceedings against the Armenian servicemen in captivity in Azerbaijan who are being presented as terrorists. Another aspect that I would like to mention is the protection of cultural heritage. This is a particularly sensitive aspect. In the case of armed conflicts with an ethnic, cultural, or religious character, it should be stressed that in all phases of an armed conflict, regardless of its character, the cultural heritage as a whole continues to enjoy legal protection. The law of armed conflict, a lex specialis in time of war, expressly regulates the protection of cultural property. In other words, the cultural property and historic monuments enjoy both general and special protection. To the extent that cultural property is civilian, it may not be made the object of attack. The respect for cultural property is of paramount importance, as this rule and the 1954 Hague Convention are widely regarded as reflecting customary international law. The results of studies on the attacks against the Armenian cultural heritage in Artsakh includes cases of vandalism against churches, cross-stones, and graves, deliberately erasing Armenian texts from them. The attacks and destructions of the cultural monuments were carried out since the first days of the war and continued after cessation of the hostilities. Since the outbreak of the war, the issues of protecting cultural and religious heritage sites in Nagorno-Karabakh has been on the defenders' radar, and we regret that up to now the UN specialized body, the UNESCO, is unable to dispatch its mission to assess the situation on the ground. Mr. Chairman, ladies and gentlemen, to sum up, one can state that despite the extensive body of international humanitarian law instruments, norms and principles, we lack effective mechanisms for ensuring the enforceability of international humanitarian law in order to prevent its violations. The obligation to ensure respect for IHL is not limited to behavior by parties to a conflict, but includes the requirement that states do all in their power to ensure that international humanitarian law is respected universally. Establishment of universal jurisdiction at national level over grave breaches of IHL and investigation of war crimes and crimes against humanity falling within their jurisdiction, as well as creation of international enforcement mechanisms, could contribute to this end. For the investigation purposes, the ICRC guidelines on investigating violations of international humanitarian law fairly define that reporting, setting forth a uniform investigative process for all states, plays a key role in ensuring compliance. The purpose of reporting, both at national and international levels, is to draw attention to an incident which in turn may trigger the steps necessary for launching an investigation. And here, the role of national human rights institutions, non-governmental organizations, media is highly important. even though the primary responsibility for ensuring proper investigation and reporting lies with state authorities. The respect for international humanitarian law norms should become an integral part of modus operandi. Therefore, relevant trainings for armed and security forces will help raise awareness among military and security personnel, thus contributing to proper implementation of international humanitarian law and state commitments and obligations contained therein. In this regard, we should welcome the increasing number of national commissions and other bodies involved in advising authorities at the national level on the implementation, dissemination and development of international humanitarian law. Human rights are universal values and they should never be politicized. National Human Rights Institution, and I do not represent the Armenian government, and consequently the Human Rights Defender of Armenia carries out its activities strictly in accordance with UN Paris principles. And in this capacity, I have to highlight that effective and efficient human rights protection, strong human rights system is secured by effective human rights prevention system of human rights violations and investigation system. Only effective preventive measures, including through thorough investigation of human rights violations, war crimes and crimes against humanity, and of course responsibility may serve established for the purpose of establishment of long-term peace and security. Effective measures should be taken also to eliminate root causes for human rights violations and violations of international humanitarian law. In this region, one of them is the Azerbaijani state-supported hatred and animosity propaganda towards Armenians, clearly amounting to genocidal policy and even to fascism. And finally, such an international authoritative organization like the OSCE specifically should prove that the internationally proclaimed principle, no one should be left behind, no one should be ignored, is to protect real people in real life, rather than a nice expression left without foundation because of becoming a victim of politics. Thank you.